Good morning, ladies and gentlemen.
Good morning.
Good morning, Judge.
Good morning.
First up, I have Mr. Roberts.
Good morning, Your Honor. How are you?
Good, sir. How are you?
I am doing well. I'm checking in on Mr. Rayshawn Foster, who is in custody at the Wayne County Jail.
Did you want to wait on him or waive his presence?
We can wait on him. I have a bond motion that I'd like to argue. Thank you.
Come back to you. Ms. Nelson, good morning.
Good morning, Your Honor. I'm filling in for my colleague Sahar Faraj on a Mr. Kenth Robertson.
Okay.
Case number 2305-9690001, people of the state of Michigan versus Kenneth Robertson. Defendant is charged in count 1, assault with a dangerous weapon, count 2, domestic violence, and so.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Sophia Nelson of Neighborhood Service, on behalf of Mr. Robertson, P77960.
And what's your pleasure, Ms. Nelson?
We would need to set this matter for a preliminary exam, Your Honor. I would also note I have not yet received any digital discovery, only paper.
Is Mr. Robertson in custody or out?
He is out of custody.
All right, the court will continue to plea of not guilty and set this matter for preliminary examination. House November 15th at 9:30.
Ms. Faraj has another exam at 9:30 that day. She has matters at 8:39, 9:30, but I could set it for 10:30.
Okay, we'll go for 10:30. November 15th at 10:30. I'll continue.
Thank you.
And I will get the digital discovery to Ms. Faraj.
Thank you, Shelley.
Thanks.
Mr. Gagnon.
Morning, sir. I got Mr. Caston. I can waive his presence if allowed. He is out of custody.
Okay. Ready on casting.
On this case number 2305-969601, of the state of Michigan versus Keith Caston. Defendant is charged in count 1 through 4, assault with a dangerous weapon. Counts 5 through 8, weapons, felony, firearm. Count 9. Defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P 0249.
Brian Gagnick, sir. P64220. May I waive my client's presence, please? I am in communication. He is on bond.
Court will waive the defendant's presence. What's your pleasure?
Your Honor, I'd like to set an examination date. I heard the court give the 15th. I'm out of town. I'm available the 17th or the 20th, if that is all right.
All right, the court will continue to plea of not guilty and set this matter for preliminary examination the 17th, November 17th at 9 o'clock.
9 a.m. the 17th. I accept.
File will be continued.
Ms. Drain, I'm not sure if I received discovery. If you got it, please send it over.
I will. No problem. Thanks.
Mr. Callahan.
Good morning, Judge.
What can I do for you?
I'm here on Avion trailer.
Okay.
I was spot appointed yesterday.
All right.
Defendant is Alicia.
I ain't kind of jealous on the phone right now about that. They want to know if you want to put her on out. Oh,
Yes.
This is Ms. Ripley, prosecutor.
Yes. Ms. Ripley?
Yes, good morning, Judge.
Good morning, Ms. Ripley. Do you know who the attorney is for Alicia Holloman?
Judge, I haven't heard from anyone yet, and I've been checking the register of actions every day, and I haven't seen anyone appointed yet.
Okay. So, Mr. Callahan, I have to get counsel for your co-defendant. Give us a moment. We're gonna have to check with the assignment clerk and see what we can get.
I'm sorry, I'm having trouble hearing you, Judge.
There's a co-defendant on this case. I have to get them counsel. It doesn't look like they have counsel assigned as of yet.
Do you want to adjourn this PCC for a day or two?
Well, no, sir, I want to get it today. You have someplace else you need to go?
Okay, can we set an exam date now? I'll waive my client's presence.
I can't do that without the co-counsel. I need to make sure that that date, whatever date I give, that they're available for that too.
Well, this is not a good morning for this to happen to me.
Okay, that's okay. I can put it over till, no, I don't want to do that.
You can put it over till when?
Can you check back with me? You have some other places to go?
Hey, hold on a second, Judge. Hey, guys. I'm sorry, Judge. Would you repeat that?
I was asking if you have someplace else you need to go. You want to check back with me?
Yeah, I got to go to Judge Gillis's court, so I can check back in half hour, 40 minutes.
Sure, that's fine.
Okay, all right.
All right.
Just so you know, I'm on trailer.
Okay, thank you very much.
All right, thank you, Judge.
Judge,
Yes.
just so you know, I'm ready on Hosen to set an exam date. I have to be in open circuit for a motion by 10:30.
Just about to call you. Who are you here on?
Kendall Hosen. He's there. He's here. It says-
Ready on.
Calling case number 2305-963501, people of the state of Michigan versus Kendall Hosen. Defendant is charged in count 1, assault with a dangerous weapon, count 2, weapons felony fire, count 3, domestic violence.
Appearances for the record, please.
Your Honor, Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Rosemary Dare on behalf of Kendall Hosen, P 37888.
What's your pleasure, Ms. Downer?
Your Honor, I would like to set this case for an exam. Unfortunately, I already have 2 exams set on November 15th. I am available on the 16th and on the 20th.
2 exams aren't going to take you all day, are they?
I'm scheduled for something at 2 o'clock also. I don't know if I could do it between 12 and 2.
What about early in the morning?
I have something in front of Judge Edwards. I have actually 2 cases in front of him and a motion.
He's usually early.
And a Zoom PCC in front of Judge Giles. Then I go to Lincoln Park for an exam. He's got 2 cases, 2 separate felony cases scheduled for exam with the same complaining witness.
How are you looking on the 17th?
I can't do it in the morning. I'm happy to do it in the afternoon.
November 17th at 12 o'clock?
I could even do it earlier than that. At my final conference in front of Judge Knapp, and he starts very early, so I could do it, 11 if that's helpful.
November 17th at 11 o'clock. Ron will be continued.
Thank you, Judge. Have a good, is it the weekend yet? No, have a good rest of the week.
Thank you, you too. Mr. Bicker. Mr. Bicker was here. Mr. Graziano.
Good morning, Judge. I'm
Good
here
morning,
for
sir.
Corney Woodruff, sir.
Corney Woodruff, okay.
Judge, I'm asking that you waive his presence at this time for the PCC. I will be requesting.
You call the case.
Okay, I apologize, Judge.
Okay.
Calling case number 2309972301. People of the state of Michigan versus Corney Woodruff. Defendant is charged in count 1, interfering with electronic communications. Count 2, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
John Graziani appearing on behalf of Corney Woodruff, P number 43387, Judge.
And what's your pleasure, counsel?
Judge, I'm asking that you waive his presence for this PCC. We will be requesting a preliminary examination, and because of my schedule, I'm requesting Friday the 17th, possibly in the later morning. I remember Sister Counsel mentioning about 11 o'clock. I could do it at 11:30 or 12 if that's possible, Judge.
November 17th at 11:15.
That'd be fine, Judge. Thank you.
All right, thank you.
Everyone have a good day and a good week. Bye-bye. Oh, Shelley, I need the discovery.
Okay, I will,
Okay.
I'll send it.
Okay, have a good day, everyone. Be safe. Bye-bye.
Bye.
Yes, ma'am, you're back.
I forgot to ask Ms. Drain for discovery. I have no paper nor digital discovery. I reached out to your prior courtroom prosecutor. She referred me to Ms. Drain. I emailed Ms. Drain yesterday. I also filled out the form last week, the prosecutor's office discovery form. So if someone could email me discovery, digital and paper, I'd appreciate it. Hi, Ms. Drain.
Good morning. Yes, absolutely. I will email, I will send you the paper and digital discovery.
Sounds good. Thank you. Sorry to interrupt, Judge. I was going to chat. All right. Have a good day, everyone.
Thank you, you too. Wayne County Jail. Deputy. Ms. Holloman, can you get the deputy for me, please?
Yes, Judge.
Good morning, sir. Do you have
Good morning.
Ray-Sean?
I'm sorry, one more time?
Do you have a Ray-Sean Foster?
Yes, he is at the old jail. I'll let them know that you're ready for him.
Oh, thank you.
No problem.
Thank you, Judge.
No problem. Come on. Good, how are you? Mr. Vicker. Mr. Bickard, are you there? Come on, how you doing? There, Nathan.
Okay. Try and get this right. Yeah.
Mr. Bickert?
Yes, Your Honor.
Good morning. How can I help you?
Good morning, Your Honor. I have Mr. Blunt for competency review.
Okay.
I'm prepared to stipulate to the findings of the report, Your Honor, and I'd just like to set an exam date.
Who's my prosecutor on that, Mr. Kleinfeld?
No, Your Honor.
Oh, that's you. What's your name?
Jaron Anderson.
Okay, let me call the case.
Calling case number 205-875-301 for the state of Michigan versus Martel Blunt. Defendant charged in count 1 homicide, murder, first degree premeditated. Count 2 weapons, stolen firearm.
Appearances for the record, please.
Good morning, Your Honor. Jaron Anderson on behalf of the people, PA 5434.
May it please the court, Your Honor. Tyrone Baker, appearing on behalf of Mr. Martel Blunt, P number 62647, Your Honor. Good morning.
Good morning. So,
Your Honor,
go ahead.
I was going to ask, Your Honor, if the court would so allow, I would ask the court to consider waiving my client's presence at this time, if necessary.
The court will waive the defendant's presence. This matter is scheduled for a competency hearing. Do we have a report back?
We do, Your Honor.
Did they find the defendant competent to stand trial?
They did, Your Honor. And as I stated, I'm prepared to stipulate to that finding. I'd like to set at this time. I'd just like to set an exam date.
Okay, the court makes the finding that the defendant is competent to stand trial. We'll schedule a preliminary examination. How is November 14th at 11 o'clock?
Your Honor, is I start a trial that I very much anticipate is going to actually go on Monday the 13th. I'm sure it will go into Tuesday the 14th. Is Friday the 17th available?
That's not my homicide there.
I'm sorry.
The 16th is available.
Can we try for the 16th? It is possible that might be done by then, or at least close enough.
16th at 11:30?
Yes, Your Honor. I was just going to ask if we could put it a little later. Thank you.
November 16th at 11:30. That works for the people as well?
It does, Your Honor. Thank you.
All right. We continue. Thank you.
Okay. Thank you, Your Honor. Everyone have a good day.
He's actually taking the night out. I'll take some of those cases.
Good morning, Ms. Marable.
Hi, I have a preliminary exam in your court this morning. If you remember, we did the probable cause on Monday, but the prosecutor never sent me the discovery, which I can still do the exam. I just need the discovery sent to me. They never sent it, and I called yesterday the prosecutor office, and I still haven't got the discovery. And it's a simple. Oh, Miss Drain is there. Is that Miss Drain?
Yes. Okay, I did send it. I'm not sure why you didn't receive it, and so I do apologize. I should have called you to make sure that you did get it. We're having a few issues with sending things.
So if you send it to me and y'all give me like a half hour, that's fine, because Your Honor, I have a plea that Judge Blunt wants me to take at 9 o'clock. So as soon as I finish the plea, I can come over.
Okay, do that then.
Okay, Shelley, you're sending it to me now?
I'm gonna send it to you right now. So if you don't get it, let me send the paper directly to your email. And then
okay,
I'll do.
That's all I need is the paper. That's all I need is the paper.
I'll send it separately to you.
Okay, bye-bye.
Good morning, sir. What's your name? Wayne County Jail. What's your name, sir? I can't hear you. I still can't hear you. You're not muted, but I can't hear what you're saying. It looks like Mr. Foster.
Yes, Judge.
Okay, recalling case 23057288601, People versus Rayshawn Foster. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, number 60249.
And good morning to Your Honor, court staff, Jonathan Roberts, P86428, on behalf of Mr. Foster, who is present by Zoom. However, his audio is not functioning. I'd ask that his presence be constructively waived for the purposes of this proceeding.
For the waiver of the defendant's presence, what's the question?
We are prepared to set this for examination. I am available on the 15th. I don't know what time slots are still open.
For the continue to plead not guilty and set this matter for preliminary examination on November 15th at 10 o'clock.
Yes, Judge. And I also sent in earlier this morning a motion for bond modification for Mr. Foster, if I could be heard on that as well.
Go ahead.
Yes, Judge. So we did have a prior exam date scheduled for July 14th, 2023. On that date, Your Honor issued a bench warrant for failure to appear. Mr. Foster has represented to me that he received some credible threats from witnesses in this case, specifically that individuals were sending messages and driving by Mr. Foster's home leading up to the examination. He stayed with a friend in Detroit so that he could avoid that. I did speak with his sister, Miss Monet Foster, who has indicated that Mr. Foster can safely reside at her house, which is located in Inkster, Michigan, and that she can provide transportation to and from work for Mr. Foster. Mr. Foster is the primary income earner for several children, and I would just ask that he be provided, at a minimum, a cash or surety bond. Presently, it's $50,000 cash only. And I would ask that the amount be reduced given his financial situation presently. And if Your Honor would be amenable to reinstating the GPS tether condition. I don't think that there are going to be safety concerns moving forward.
Did he cut his tether off?
That is what I have in the file, Judge.
So absolutely not. Fine, continue.
Yes, Judge. And Mr. Foster, I will visit you later this week, okay?
What time is that exam?
Number 15 at 10 o'clock. Okay, who do we have here?
This is the 9 o'clock, Judge.
Ms. Fawaz. Calling case 2359339 before the state of Michigan versus Nina Ahmad Fawaz. Defendant is charged in count 1 assault with a dangerous weapon, count 2 felony fire. Appearances for the record.
Good morning, Your Honor, Shelley Drake, from the people, P number 60249.
Good morning, Nicole Sadi. I represent Ms. Fawaz, who is present. The state to my left.
There's date, time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. There are some issues involved in this case. I would ask for a side.
Okay.
You're done.
Okay, we are back on the record on People versus Fawaz. After sidebar conversation, it's my understanding that the complainant witness is not available, and we don't have a definite period as to when the witness will be available. That being said, the court will entertain a motion. Let's.
I move to dismiss, Your Honor.
So, or the court will dismiss this matter without prejudice.
Judge.
Page number's right there.
Mr. McAlpine.
Yes, good morning, Judge.
Good morning, sir. What can I do for you?
I have not James Garner, Justin Reed on a PPC. I believe he's on the call.
Yes, okay, we're ready on Justin Reed.
Judge, is it possible to speak with him in a breakout room for a couple of minutes?
Go ahead and break out room.
Thank you.
Mr. Robertson.
Yes, yes, sir.
Your next court date is November 15th at 10:30. That's in person in 36th District Court.
36th District, and you said that's when?
November 15th.
No.
At 10:30.
Okay. So what happened today? Anything happened today?
You set the court date for November 15th at 10:30.
Okay. At 10:30?
Yes, sir.
All right. Thank you. I'm done.
Yes, sir. You're all set.
All right. Thank you.
Good morning.
I'm putting my name to the day. So we have a list of J.
Yes, we have three of them. It's Night, Nellon, Crane.
Mr. McAlpine, you ready?
Ready, Judge.
Recalling case 2305969201, People versus Justin Reed. Oh, I don't think you read the original charge.
Defendant is charged in count one, motor vehicle, unlawful driving away, count two, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Judge. Warren McAlpine, P number 52522. I'm here on behalf of Justin Reed, who is present, appearing via Zoom. We consent to the Zoom hearing.
Unmute yourself and tell us your name, sir.
Justin Reed, Senior.
What's your pleasure, Mr. McAlpine?
Judge, we'd like to set this matter for an in-person preliminary exam.
The court will continue to plead not guilty and set this matter for preliminary examination on November 15th at 9:15.
Let me check that, Judge. That's a good day for me.
All right, November 15th at 9:15. Bond will be continued.
Thank you. Have a great day.
Thank you, too.
Goodbye.
You're all set, Mr. Reed.
All right, thank you. Have a good one.
You too. Ms. Holloman, we're just waiting to get you an attorney, okay?
Try to give her attention. She had to ask. Yes. So. Check the drive. Yeah.
She said she may be a little late. 9:45.
Yeah.
Yes, sir, can I help you? Can I help you?
Yes, I was spot assigned for Miss Hollandaise.
Okay. No, it's not. Waiting on your co-counsel to get back.
Okay.
I did. It was the last minute thing. Bear with us on that. Bear with us on that.
Exactly. So, yeah. Oh my God.
Whatever was the plan, I was. I didn't send message. Maybe I'm still. Huh?
Mark, run the once the answer. No. No, so it's nine.
Russia's the one that says she's.
Double check. Real quick.
That's right.
It's supposed to be Mike. Got it.
Mr. Caston? Mr. Caston? Next, your audio, sir. Did you have witnesses here or with you?
Right, let's try this again.
Kendall Night. Hey.
All right. All right, so we went from 8:05 to 9:05.
That's okay, don't worry about it. 17, 9 o'clock, that's in person. Yes, sir. You want me to late bird?
Sorry.
One in late bird.
I know, Your Honor. I apologize. It's Romulus.
Are you ready on Martin Luther here?
We are ready.
Calling case 2359560, people of the state of Michigan versus Martin Luther Lanier Jr. Defendant is charged in count 1 assault with a weapon, count 2 domestic violence.
Good morning, Your Honor. Madison Earl on behalf of the people requesting permission under NCR 8.120B under the supervision of Attorney Shelley Drake.
Permission granted.
Good morning, Your Honor. Neighborhood Defender Service by Summers Rush, P number 85828, a hearing on behalf of Martin Lanier. Present today, Mr. Lanier, please state your name and record.
How you doing, Your Honor? Martin Lanier Jr.
There's a date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
How many witnesses for the people?
One.
Okay, call your witness.
Your Honor, at this time, we call to 12 Bruce.
And please step forward, give your name and the spelling of your name. To the young lady seated here, give your name and spell it for her. Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat in the witness box right next to me. Your voice up nice and loud and speak into that microphone that's to your left, okay? Maybe Kim, when you're ready.
I'm good. Good. If there are any questions that you don't understand, just please let me know so I can rephrase them, okay? Okay. Can you please state your name for the record? Chantel Bruce. Thank you. I want to draw your attention to October 22nd, 2023. Where were you on that day? I was in front of my home. Okay. And just to clarify, that's your home? Yes. Okay. And what is the address of that? 8049 Patton Street. Okay, and that's in the city of Detroit? Yes. County of Wayne? Yes. And what happened while you were in front of your home on that date? I got out of my car. The defendant was parked in the middle of the street. I was walking towards my house. He got out the car with 2 weapons and was coming towards my house as I was going towards my house. Okay, so just to rephrase, so you said you got out of your car and the defendant was outside of the home? Yes. Okay, and what happened next? He approached my house and used his weapon. Okay, and can I would, who is the defendant to you? He is my son's father. Okay, and do you see that individual here in the courtroom today? Yes. Okay, can you please point to that individual and identify a piece of clothing that he's wearing? He's right there with the white shirt on. Thank you. Your Honor, please let the record reflect that the defendant has been identified.
So noted.
Ms. Bruce, going back to when the defendant came over, did you invite him over? No, I did not. Okay, and you mentioned that he had weapons in his hand. Yes. Can you please explain what those weapons looked like to the court? It was a metal weight and tree shears. Okay, and what was his demeanor like while those weapons were in his hand? He was hostile. And what was he doing with those items? He had them in his hand, approaching me in my house. Okay, and was he saying anything while he was in possession of those items? Yes, I don't recall the exact words, but he was cursing. Okay. And Mrs. Bruce, based on the testimony that you've given here today, how would you describe that you felt in that moment? Scared. Your Honor, I don't believe I have any more questions at this time.
Cross-examine.
You and Martin were having a disagreement about money, right?
Yes.
You wanted Martin to give your son, I think it was $75?
No, it was actually $300.
And he told you he could give you $75 that day?
He told my son.
He told your son, okay. And so the day of the incident on October 22nd, earlier that day, you had gone over to Martin's home, right?
Yes, with my son.
With your son, right?
Yes.
Okay. And your son ended up breaking the windows in Martin's home, right?
He was knocking on the window and he actually
He broke the window.
Yes.
Okay. And you were with him when he did that.
Yes.
And then you got back to your house.
Yes.
And so So, and then Martin came over to your house.
Yes, Martin
And
called
he-
me and told me he was coming to my house
And he told you that he was gonna bust out the windows of your house.
and beat me and my son ASS.
Well, you testified that you don't recall that exact words.
This
You
was
changed your
before,
testimony.
not when we got to the house, this was before he got to my house.
Oh, okay.
Because you were referring back to when I was at the house with my son, his house.
Okay, but you don't recall what you said to you at your house.
At this point, because he had out a weapon, I was scared and distraught.
Okay, and how far away from you was he?
Oh, he was not even 1 feet.
Not even 1 feet?
Yes.
Your husband pulls a gun on him,
Yes.
correct? Okay, and, all right. If I can have one more. And did you laugh at Martin?
No, I did not. I
You
was
didn't
actually
laugh.
crying.
When he told you, why did my son come to my house and break my windows, you laughed at him.
I said, I don't know.
You said, I don't know, and then you laughed. Objection, Your Honor, as the answer.
Okay, I'm gonna have one attorney on each side.
Objection, Your Honor. She already asked the question and it was already answered. Your Honor, I was just seeking clarification, because I don't think I got a direct answer. But I'll move on.
One second, Mr. Callahan, we're almost there.
And you don't, no further questions, Your Honor.
Can you redirect?
No redirect, Your Honor.
Give me one moment. We are ready on Holloman and Trey. Yes.
Calling case number 23059570. For the state of Michigan versus defendant number 1, Alicia Holloman, and defendant number 2, Avion Trader. Both defendants are charged in count 1, homicide, felony murder. Both defendants are charged in count 2, child abuse. Both defendants are charged in count 3, torture.
Hearing six for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good morning, Your Honor. Evan Callahan, P30564 on behalf of a defendant trailer.
Mr. Docket. Mr. Docket was here. Okay. Back on the record on people versus Lanier. Ma'am, you say you and the defendant have a child in common, is that right?
Yes, Your Honor.
You weren't in a relationship with him at this time, were you?
No, Your Honor.
You said that the defendant was coming towards your house with what in his hand?
It was, metalweight and tree shears.
What did he do with that metalweight and tree shears?
He had it in his hands like he was aiming it towards me in my house.
Demonstrate what you're talking about.
Okay. Both of it. Weapons in his hand, and he's coming towards my house. Yeah, and he's going did get to that point because my husband was being put out of the building, and he turned around and went across the street to my house.
Say anything else?
Yes, he was yelling all kinds of stuff. At that point, it just went in and out one ear.
Any questions based on my question?
No, Your Honor. No, Your Honor.
Thank you, ma'am. You may sit down. Any other witnesses for the people?
No, Your Honor.
Any witnesses for the defendant?
None for the defense, Your Honor.
People?
Your Honor, at this time, we're going to ask to find over as far as to reserve any argument. Your Honor, at this time, we object to the find over and ask for a dismissal of this case. It is not the burden of probable cause, that it specifically regarding element 3 under the Michigan model jury instructions, assault with a dangerous weapon. It says the defendant intended either to injure or to make the complainant reasonably fear an immediate battery. Her testimony shows that she says that he was holding the weapon just in his hands like this. That was her testimony right now, not aiming them. And she also testified that he was going towards her house, not her specifically. So, Your Honor, based on that testimony, and also she says she doesn't remember what he said or he was yelling. Everything he said went in and out one ear. So there's no testimony that suggests that he said anything threatening her specifically. He was mad because his windows were broken too, and he was expressing that anger, but he did not commit felonious assault in this situation. I have not met that bystander probable cause, and I asked for this.
Yes, Your Honor. Actually, to the contrary, I would say that throughout Mrs. Bruce's testimony, she quite literally stated that she was scared and in fear, and stating that she was hearing things with one ear, not the other. I would think would actually further prove that element of the fact that she was in fear of an immediate apprehension. Because when you are scared, you are not paying attention. You're not necessarily listening to what everyone, to what all of the words are saying. And like I stated, she even testified that she was scared and that the defendant was walking towards her. She also testified that he was just less than a foot away from her. So, with all of that coupled, Your Honor, we would still ask that the court find this matter over to the circuit court.
All right, the defendant is charged with assault with a dangerous weapon, meaning that he had to put someone or a reasonable person in fear or apprehension of an immediate battery with a dangerous weapon. And although this garden shears and this metal weight are not dangerous weapons in and of themselves, they can be fashioned as such as a dangerous weapon. However, the testimony coming from the witness indicates that the defendant was coming towards her and was threatening to beat her AWS. Didn't hear any testimony that he swung or threw or otherwise tried to use those shears or that paperweight as a weapon. As such, the court finds insufficient evidence to bind over on count 1, assault with a dangerous weapon. We'll dismiss that count. Now, the misdemeanor doesn't have to be shown here at preliminary examination. That can be set for a pretrial. But I'm not so sure based on what I've heard, would be inclined to dismiss count 2. Or, like I said, for a pretrial for Judge Austin here on domestic violence.
Your Honor, I would have to ask the prosecutor on the case, but I do believe I would, yeah, I would have to ask the prosecutor on the case before we can set that to for domestic violence.
So hang on a second, pretrial for domestic violence.
Thank you.
November 29th, 8:30.
November 29th at 8:30, pretrial before Judge Austin Garrett.
Thank you.
Sorry.
Judge,
Yes, sir.
on Avion trailer, I tell you what, I had a court require my attendance today at 10:30 in Southgate, Judge Mullins. And I'm across the street at Frank Murphy, so I have to leave.
You can get Mr. Gonick back, this won't take more than a minute.
Okay,
He was here and waiting. Not sure what's going on now. Mr. Gonick. Okay, let me try this, Mr. Callahan. Are you available November 16th at 10 o'clock?
yes. Yes,
Okay, I'll check that with Mr. Gonick, November 16th at 10, as well as, we don't do it November 16th at 10. We'll have to come back November.
that's for purposes of preliminary exam, right?
Yes. I can do it anytime on the 30th. Are you available anytime on the 30th?
I'm sorry, I didn't hear you, Judge.
Said I'm available anytime on November 30th. Are you available on the 30th?
I could probably do the 30th.
All right, Ms. Ripley, does the 16th or the 30th work for you?
Sorry, Judge. November 16th, let's see.
That's at 10 o'clock.
That looks like it should be good.
Okay, I'll keep fingers crossed to see if Mr. Gonick is available. How about the 30th as an alternate date?
The 30th, I would not be. I am up at a training in Mount Pleasant that I help teach at.
How much discovery is there, Miss Ripley? Is there a ton of discovery?
There is quite a bit of discovery. I did send you a kids talk order just for those.
Okay.
It
So
is,
you want to do the
there's quite a
exam on
lot.
the 16th. You want to do the exam on the 16th, right, Judge?
Yes.
Okay, well, I'm good with that.
And Judge, I would just note, I would plan to be calling quite a few witnesses. While I do expect their testimony to, not be super lengthy, there will be a number of witnesses.
How many?
Okay.
I anticipate at this time anywhere between 7 to 10 potentially.
Miss Ripley, would you be kind enough to?
I will send a list of the witnesses. I will that
give
I'm
me your
planning to
cell
call.
phone number too.
Yes.
Okay. And I don't know, is this might sound stupid. Is Miss Avion trailer male or female?
It's a male.
Okay. All right, well, I'll be over, I'll waive his presence for today's purposes.
Okay, let's call it.
Recalling case number 2305-9570, Michigan versus defendant number 1, Alicia Holloman, and defendant number 2, Avion Trey. Both defendants are charged in count 1, homicide, murder. Both defendants are charged in count 2, child abuse, first degree. Both defendants are charged in count 3, torture.
Well, there's Mr. Gunn. Appearances for the record, please.
Good morning, Your Honor. Ben Gonick for Ms. Holland.
Good morning, Your
Good
Honor.
morning.
Evan Callahan. Good morning, Your Honor. Evan Callahan on behalf of Mr. Traylor.
And good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
All right. And ma'am, tell me your name for the record. Ms. Holloman, tell me your name for the record. I can't hear. In any event, so we were discussing some dates in your absence, Mr. Gunn. Okay, we came up with how's November 16th at 10 o'clock.
November 16th. And Judge, do you have an alternative date? I have like 8 things up in Oakland County that morning.
Unfortunately, Mr. Johnson.
Pardon me?
I said, unfortunately, oh, you know what? How about November 21st, guys?
That's good with me, Judge.
November 21st should be a good date for me, Judge.
That works for me as well, Your Honor. Thank you.
Okay. Let's do November 21st at, we can do a 10 or 11:30.
We do 11:30?
11:30.
Yes, Judge.
November 21st at 11:30. Why don't we continue? That's both defendants.
Thank you.
And I presume Ms. Ripley, Mr. Gonnick's going to need discovery as well.
Yes, absolutely.
All right. Thank you.
Thank you so much.
Thank you.
Thank you.
Thank you very much, Judge.
You're all set, Ms. Holloman.
I have a question, if I may. Which one was my attorney?
Your attorney was, they're both older and gray hair, I know. Mr. Gonnick was your attorney. I don't know if you knew which, that was the one that we were waiting on. I kept calling his name, and he finally came in. The one who said he has 8 other matters in Oakland County, that was your attorney. Okay?
That pretty good?
Yes, you're free. Thank you. Okay, thank you for your patience, counsel. You're here on Kenth Night. Okay.
Stand next to your attorney.
Calling case 2359542, State of Michigan versus Kenyatta. Royal Knight, excuse me, What is it? Royal Knight. Defendants charged with count 1 assault with intent to great bodily harm, less than murder or by strangulation. Count 2 domestic violence.
Good morning, Your Honor, and may it please this court, Gabrielle Pruitt requesting permission of practice under Code Law 8.210 under the supervision of APA Shelley.
Permission granted.
Thank you, Your Honor.
Good morning, Your Honor. Norleen Isaac, P83018, on behalf of Mr. Kenyatta Knight, is present, standing to my left.
Tell me your name for the record, sir.
Kenyatta Night.
There's the date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
Yes.
How many witnesses for the
Just one.
okay, call your witnesses.
The people called Tracy Parker.
Ma'am, please step forward, give your name and spelling to the young lady seated here. Give her your name and spelling. Ma'am, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat next to me in the witness box. Keep your voice up nice and loud and speak to that microphone that will be to your left, okay? Maybe get me ready.
Good morning. Please give your first and last name for the research. Ms. Parker, can you pick that mic up from the bottom and sit it on your lap? And do your best to speak directly in the microphone for me. Thank you so much. Will you again state your name for the record?
Tracy Parker.
Ms. Parker, do you know someone named Kenyatta Night? How do you know Kenyatta Night?
Speak to the microphone for me, I can't hear you.
A friend.
How long have you and Mr. Knight been friends?
Like 9, 10 years.
During those 10 years, you came to know what he looks like?
Yes.
Would you recognize him if you see him today?
Yes.
Do you see him in the courtroom?
Yes.
Can you please point to him and tell the court item of clothing he's wearing? Let the record reflect identification as the defendant.
So noted.
Ms. Parker, I want to talk to you about the date of October 22nd, 2023. Do you remember where you were on that day? Where were you?
And Mr. House.
What city is Mr. Knight's home in?
Trading Street.
And is that in the county of Wayne?
Yes.
Did something happen while you were at the house?
Yes.
What happened?
I was leaving from my house. I had to use the bathroom. I had to have a key to open the door. And I came in the door. Mr. Knight was sitting in his chair where he always sat.
Ms. Parker, I want to go back. You were coming into Mr. Knight's home to use the restroom?
Yes.
And you just testified that when you entered the home, you see Mr. Knight.
Yes.
What happened when you see Mr. Knight?
I was going to put my keys down on the table, was on the right hand side. And the music was playing loud. And he just said, "Bitch, where's my tablet?" He got my tablet. And I didn't get a chance to say anything. He just ran up to me and grabbed me by my throat. Go ahead.
Ms. Parker, when he ran up to you and grabbed you by your throat, was he using one hand or two hands?
One.
And what was he doing with his hand on your throat?
So
would you say he was squeezing?
yeah.
And you just testified that you ended up against the wall?
When you walk in the door, that was that door. When you walk in, that was that. Right here at the table. And as I was trying to get up the step, and like I said, he just was like, "Bitch, where's my tablet?" And I didn't just say anything, so he came towards me. And just grabbed me, so it's like I'm against the wall, not the hallway part, like this side right here. And I'm like, just like trying to talk.
Ms. Parker, do you know approximately how long he was holding your throat?
For a couple of minutes. Just gagged. I'm like, "Oh, let me go, just let me go, let you know my."
And Ms. Parker, did you just say you were gagging?
Yeah.
Were you having difficulty breathing?
Yes.
Were you at some point able to get away from Mr. Knight?
Yes.
When you got away, what did you do?
I turned around and I was like, let me go, let me go, leave me alone, leave me alone, and I had him, I'm trying to get back out the door, he grabbed me by my hood. It's like, bitch, get the fuck out of my house, and I'm trying to say, I'm going, and I'm just looking busy. And I'm trying to just get out the door, and just as I'm walking, just trying to get to my car. But I get to my car, he had me, and once I get there, I got a hand lock my doors, trying to lock my doors, get to my phone. And I get to my phone.
Miss Parker, I'm so sorry, your knee is making the microphone pick up some noise. Based on your testimony, did you just testify that you were able to get away from Mr. Knight? And did you just testify that when you got away from Mr. Knight, he followed you to your vehicle?
That's just grabbing me by the hood, yes.
Once you got into your vehicle, you testified that you locked the doors?
I was hand locked the door.
And once the doors were locked, what did you do?
Just put my phone, I'm busy, I'm just, my phone and my purse, I'm just trying to get to my phone. Because now I wanted at the same time, I'm looking. And I see I'm going to be going to this, my favorite. Well, now,
No more questions, President.
Cross examine.
Yes, Judge, please. Ms. Parker, you just testified that he grabbed you by the throat, threw you against the wall, and then you stated that he used one hand and he held it there for a couple minutes, you were gagging. So did he grab and shove you into the wall, or was he holding onto your neck for a couple minutes, you couldn't breathe, and then pushed you into the wall?
grab me by my throat, ran up to me, grabbed me by my throat like this and choked me, saying that I was terrible. I'm talking, couldn't talk to him. Next you know, he got pushed me, bam. This was right there. You have this paper towel thing that walks in, right here. Right?
Did you tell officers that he pushed you into the wall? Did you tell them that he choked you? Tell them that he had his hand on your neck for 2 minutes or so? Yeah. Did you go to the hospital that night when the ambulance was called? Why? Did you drive yourself to any other hospital that night? Following day? No. Did you have any injuries to your neck? That's correct. Were pictures taken by officers that night that showed the scratch on your neck? Did you take a picture of your neck that night?
Yes.
Did you provide that to the police? Did you provide that to the prosecutor? Do you recall telling officers that you had other health issues when you told them that you couldn't breathe? Had blood pressure, anything else? That's all, Judge.
Really are. Ms. Parker, you just testified that after the incident, there was a scratch on your neck. And you said that you took a photo of that scratch. How did you take the photo?
It was in my house. The next day.
Your phone. Do you still have that photo on your phone? Are you able to provide that to the prosecutor if we need it?
Yes.
No more questions, Your Honor.
Thank you, ma'am. Next up. Any other witnesses for the people?
No, Your Honor.
Any witnesses for the defendant? People.
The people most of bind over as charged and reserve any argument. Judge, with object to bind over, specifically with respect to count one, assault by strangulation and substitution. I know she said that she had been choked for a couple minutes and she didn't go to the hospital. There were no physical injuries that we're aware of. The officer on the scene, although he's not here, testified, didn't notice any injuries, and there has been shifts in her testimony. Right, Judge.
So what are we talking about?
That's all.
Right, she did hear a testimony about choking her to the point that she gagged.
Yes.
You have to concede that would meet the statute elements of strangulation.
I would, Judge.
Court after hearing the testimony of the complaining witness is satisfied that the burden of probable cause as it relates to the charges contained in the court finds that the charges were committed in the city of Detroit. The court finds probable cause to be listed in the and it will be bound over to Wayne County. There's a criminal division of proceedings. His arraignment on the information date and time will be November 15th, 2023 at 9:00 a.m. Bond will
Thank you, Judge. Thank you, Judge.
Mr. Devo here?
Yeah, Your Honor.
Mr. Cohen, how are you?
Good morning, Your Honor. Fine. How are you?
Good. All right, witnesses here on your case, sir?
I believe they are, and I just wanted to speak to Mr. Nellon about whether he wants to waive. He's just being brought up.
Okay, this will be the day I have witnesses show up and I have them super crowded time.
But it rains, it pours, right?
Yep.
Oh, hi, all right, did you call me up?
Yeah.
I heard it over here.
Everybody.
Well, we can always ask them.
Give a quick thing, one of those, and the other ways, I mean, that. Would we do that? Or you okay with that?
So what are we doing?
I just wanted to confirm with Mr. Nellon whether he wants to waive, I think that people are willing to allow us to waive all 4 of his exams. I need to confirm whether he wants to do that since the complainant is here today.
Okay.
So just waiting for him to be brought up. Okay.
All right.
Get you guys out of here.
I'll see you.
Your Honor, can I have a couple minutes, just go talk to my co-counsel here? Wherever he's at.
He's in here. He's in the witness.
Oh, he's in the back, okay. Thanks. Your Honor, while we're waiting, is it okay if I take my client outside and talk to her a little bit?
attorney said someone told her. So, person.
On other, and then it's like, leave the next day, so I was told. He's not. So I was told this violation hearing today. Just confirming that nothing's on register yet.
Judge, for Mr. Nellon, he's prepared to waive in 3 cases, and I think 1 case is being dismissed by the people today as a duplicate, essentially.
Which one is that?
It is a case with the sole charge of stalking, and I don't have the case number handy off the top of my head. Okay, it's just the one with single count. Thank you.
Come on. Okay, hold on again.
I'll be real quick.
Hold on a second.
Kind of warm in here. Officer, how many step on that? We gotta get on the kind of like this. Calling case 2359499, state of Michigan versus number 1, Rell Nellon. Defendant number 2, Jasmine M. Both defendants are charged in count 1, witnesses intimidating, committing crime, threatening to kill or injure. Defendant 1 is charged in count 2, assault with intent to great bodily harm, less than murder by strangulation. Defendant 2 is charged in count 3, assault with a dangerous weapon. Defendant 2 is charged in count 4, count 5, felony firearm. Also, defendant 1, Rell Nellon, has case number 2359506, charged in count 1, larceny of building. He has a provisional pending court defense notice. He has case 2359505, charging count 1 home invasion, first degree, count 2 aggravated assault, count 3 domestic violence, second offense notice, domestic violence and or knowingly assaulted the defendant, 1 second offense notice. Defendant has a provisional pending court defense notice, and he has case 2359500, charging count 1 aggravated assault, and it has a provisional pending court defense notice. Appearances for the record.
Good morning, Your Honor. Shelley Green for the people, P number 60249 on all cases.
Good morning, Your Honor. On behalf of Mr. Rell Nellon and all of his matters, Jonathan Cohen from Neighborhood Defender Service, P86151, appearing with Mr. Nellon, who's present and in custody. Mr. Nellon, can you please state your name for the record?
Rell Nellon. Your Honor, Ronald People, P6897, on behalf of Jasmine Mitchell, who's standing here tonight, allow you to please state your name for the record.
Jasmine Mitchell.
This day and time set for preliminary examination, and we're ready to proceed.
Yes, Your Honor, I am prepared to proceed. I have my witness ready for all cases.
On behalf of Mr. Nellon, Your Honor, I believe it's his wish to waive the examination in 3 of the matters, and I believe people had a motion to dismiss a duplicative case.
That is correct, Your Honor. After speaking with defense counsel, case ending in 5001 is charged aggravated assault. Your Honor, and I, as up, it is duplicative. It is the same date of offense for one of the other cases, so I would not be going forward. I would do.
The court will dismiss that matter without prejudice. And that would be case number 2359500. All right. As to the other matters, you need to sign the waiver forms. Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes. Raise your right hand, sir. All right. You understand you have a statutory right. You understand you have a statutory right to have a preliminary examination in all of these matters. But by waiving the same, you won't have a preliminary examination in any of them. You understand that? You understand the nature and the purpose of the preliminary examination?
Yes.
You understand if you were to have one, the prosecution will have to establish that the crimes which were committed in the city before that there's probable cause to believe you committed.
Yes.
Is anyone forcing you to waive your right?
No.
Is anyone promised you anything?
No.
Are you waiving your right freely and voluntarily? Yes. Any objection from the people?
No objection, Your Honor.
Court finds defendant's waivers are made knowingly and voluntarily. The court is binding defendant over on each matter to Wayne County Third Circuit Court Criminal Division proceedings. His arraignment on the information of each of the matters will be November 15th, 2023 at 9 o'clock a.m. Final meeting.
Thank you, Judge.
Thank you, Your Honor. Hold on. Actually, I'll see you upstairs on the left.
So as it relates to Ms. Mitchell, Okay, back on the record on case number 2359499, people versus defendant number 2, Jasmine Mitchell. Appearances for record.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Ronald People, P6897, on behalf of Jasmine Mitchell.
Tell me your name again for record.
Jasmine Mitchell.
Okay, are we ready to proceed?
Yes, sir.
How many witnesses?
One good.
All right.
Your Honor, may I interrupt? Upon further consideration and having talked to Mr. Reinell's attorney, we're gonna wait. Not too late.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have one. You'll be bound over to Wayne County Third Circuit Court as a state charge.
Yes.
What you mean? You understand the nature and the purpose of the preliminary examination?
Yes.
You understand you want to have one, the prosecution will have to establish that the crime is charged in the city of Detroit.
Yes.
Is anyone forcing you to waive the right?
No.
Is anyone promising you?
No.
Are you waiving the right freely, voluntarily?
Yes.
The objection from the people?
No objection, Your Honor.
Court finds the plaintiff's waivers made only voluntarily, freely given the court, therefore binding the to Wayne County Third Circuit Court, criminal division for the proceedings. Per arraignment on the information, date and time. We're going to keep the files together, so it will be November 15th, 2023 at 9 o'clock a.m. Final presentation.
Thank you very much, Your Honor. We'll talk. Okay, I got it. Thanks.
For this case, I would just want to reiterate that there is like no contact order.
Now, we understand what we mean by no contact, right?
Yes.
That means by way of you and third party, text messages, Twitter, Instagram, Facebook, all that stuff, got it?
Your Honor, my client's currently on a tether, but she does have a job, and I was wondering if we could make an accommodation for her to.
Why can't she work her job and be on the tether?
I don't know. Does she have permission to do that?
I was told.
She's on house arrest.
Yes.
So you work.
Motor City Grill is a few blocks from my house.
How long have you been working?
Over 10 years.
What do you do?
I'm a waitress and manager.
People?
I am not objecting to other being.
What's your working hours?
7 a.m. to 3 p.m.
Okay, send me a stipulated order to that. Working hours.
All right. Also, I have one other request. I'd like my client to be able to go to police precinct that she, in her area where she lives, to get a police report that might help our case. Does she have permission to go to that?
Why does she have to do it?
She doesn't, but, save me some time. But I'll go. I mean, she's one of the files. I think that it's,
I don't think that's actually necessary.
very well, Your Honor.
Okay.
Will we conclude it?
Yes, sir.
Thank you, Your Honor. Thank you.
Great.
I'm here, Mr. Reynolds, and Ms. Strand is the CEO.
Okay, great. Ready to go? Where's Mr. Reynolds? There he is. Come on up, sir. Calling case 2359543, people of the state of Michigan versus Samuel Reynolds. Defendant is charged in count one assault with a dangerous weapon. Appearances for the record.
Good morning, Your Honor. Shelley Green with the people, P number 60249.
Carla Marable, P number 62755, on behalf of Mr. Reynolds. Mr. Reynolds, state your name.
Samuel Reynolds. There's a date time set for preliminary examination. Are we ready to proceed?
Oh, I'm sorry.
Your Honor, I am not able to proceed at this time. The complaining witness was notified of today's date and final location for the preliminary exam. She is not present, and I cannot proceed without her testimony.
Your Honor, we ask. Ask for dismissal, Your Honor.
So ordered. Dismiss this matter without prejudice.
Thank you.
Thank you.
You see everything paper?
Yeah.
Witness.
Yeah, I mean,
Yeah.
Hey,
Judge,
haven't seen you in a long time, Mr. Lumberjack.
I know, I didn't even know you were on the second floor.
I gotta move it around, you gotta stay with me. Keep up.
I'm trying.
You ready on the crane?
Yes, approach, yes.
Come on up.
Oh, thank you.
Mira, everybody is right.
I think she has to talk with you.
Oh, he signed it already. So, is your team winning? Massachusetts? You get a lot of miles. Okay, yeah.
No.
Mr. Reed, where did she go?
Yeah.
All right. Good, how about yourself? Good. Brandon Crane.
You need him up here, Judge? It's a witness.
You want to waive your client's presence? No?
Not this guy, he's,
Okay.
this is a weird case.
You need the witness, did he go back down?
Not yet.
Not yet today. You'll need today.
We'll need him today. That is, I'm gonna have to investigate this detainer.
Yes, Judge.
Maybe we'll do that now. Okay. Let's deal with it.
You want him in the witness chair?
No.
Sir, come on. Go to the podium.
Okay, this is in the matter of William Weems Jr. File number 23059386601. Appearances for the record, please.
Good morning, Your Honor. Anna Bicker, staff on behalf of the people, P82215.
Good morning, Your Honor. Neighborhood Offender Service of Detroit by Natalie Phelps, P83355. Here on behalf of Mr. William Weems, who's present in the courtroom. Mr. Weems, can you please state your name for the record?
So Mr. Weems is before the court when he witness detained.
And Judge, for the, I haven't seen the detainer. I don't know if I could take a look at that before we proceed further this morning.
It's
But
just basic boilerplate detained. It doesn't really set forth any facts. But you're free to look at it.
thank you, Judge. May I approach?
Sure.
Okay.
It's just a bunch of copies of the same.
So why did the people request a witness detained from Mr. Williams?
Yes, Judge, based on the information that I actually spoke to Mr. Williams myself and from the officer, was the people's understanding that he was evading service. The officer in charge did speak with Mr. Williams, who told him he wasn't coming no matter what, he's not going to testify. And then after that, when the officer tried to contact again, he had shut down his phone. So I reached out to the probation agent to see if she had an updated phone number. At that point, somehow the probation agent actually gave Mr. Weems my cell phone number. And Mr. Weems reached out to me and said that he's not coming, he's not going to testify no matter what, he doesn't want to be involved, he's not coming.
And Judge, Mr. Weems was never subpoenaed in this case, is my understanding. There was.
How can they subpoena these evading service?
Well, I didn't hear any facts about the evading service, Judge. I don't think this is actually doing that. Nobody tried to pursue the service with the subpoena.
Well, we'll take, somebody tells you what they're gonna do, somebody tells you who they are,
Well,
then you believe.
Judge,
He's not coming and he's not testifying.
Judge, it's my understanding that during his conversation with Ms. Bickerstaff, he also did indicate that he was represented by counsel and he would speak with his counsel, which is me. And after that is when this witness detainer was sought, and it was done ex parte, even though Ms. Bickerstaff knew that he was represented by counsel. And that's where the issue happens, Judge, is that he let her know he would speak to his counsel, and then after that, they still issued the detainer. So obviously, if he's seeking counsel, you know, if he was given a subpoena, then he would have had the opportunity to comply with the subpoena, and he never was given that opportunity.
And Judge, if I could just add what Ms. Phelps somehow left out, it was that after Mr. Williams told me that, she was my next call, and I did speak with her, and I told her, here's what your client said, try to talk to him, tell him what's going on, tell him what's gonna happen if he doesn't come, and then let me know, and I never heard back from Ms. Phelps, and that's when the people saw the detainer. I did give Ms. Phelps and Mr. Williams the benefit of the doubt, hoping she walked in, and I never heard back.
Judge, it's not my responsibility to walk witnesses in for the prosecution. If he was subpoenaed,
That's why your witness is in jail.
all right, I understand that, Judge, but so as far as today, it sounds like the hearing is not moving forward. So I guess I'm wondering what the court is wishing to do from here. We're asking for the detainer to be set aside. Obviously, he has counsel, obviously he's here today, and will comply with any subpoena he's served.
I'm not confident in that at all.
But Judge, again, nothing has been put on the record about him being personally served. He's had counsel advise him about a subpoena, and he hasn't been
And
subpoenaed.
yet,
If he's handed a subpoena right
and
now,
yet counsel didn't even secure his presence. Right?
you're saying it's my responsibility to secure somebody who's not been subpoenaed?
Okay, so let's follow your logic then. I let him out, he doesn't show up, you're gonna come here and say, is it my responsibility to have him show up?
Yeah, that's right.
Okay, so no, I'm not gonna rely on you to get him here. I'm gonna take him for his word that he's not gonna show up.
One moment,
He'll
Judge.
stay here until the preliminary examination.
And Judge, again, the word that he gave to Ms. Bickerstaff was before he consulted with counsel on complying with the subpoena. And he has not been issued a subpoena, and he will comply with the subpoena.
I don't think so.
Can we see on the record, Judge, what makes you believe that? And maybe he have an opportunity to tell you that he will. Now that he's had an opportunity to consult with counsel. Judge, could I have a moment with Mr. Reeves? Okay.
Are you ready?
Mr. Weems would just like to clarify that the reasons why he was saying that he wasn't going to come and testify when he was interviewed by the police. They did a video recording of him, and it was his understanding that he would have to come into court and testify. It was actually what the officer told him. It was his understanding of what the officer had told him, and so that's why he was saying he wasn't going to come to court until his duty in this case was done. But he absolutely will comply with the subpoena and be here on November the 30th for the next hearing.
So let me hear it from you. Why did you indicate to the prosecutor that you weren't going to show up?
Because I had a different case going on. And long story short, they approached me before I talked to you.
Can you step to the podium so I can hear you through the microphone?
Here,
Yes, sir.
I had a different case going on. For that case, they approached me and I made a video from they having in this case for that. And he basically told me that if I did this one, the gun that he took, and I wouldn't, basically he'd give my gun back, and I wouldn't have to do like in person court thing for him. This case was like I basically doing this case. Yeah. So
It was, weren't you made aware that you were supposed to be here to testify? That they wanted you to come in and testify?
Absolutely, yes. But I made a video because he said I would have to testify.
But you understand that you do have to testify, right?
I do not, yes.
Judge, I'm just indicating, when I spoke to Mr. Williams on the phone, he did say the same thing about, he thought there was a video, so he doesn't have to come, and I told him that's not the case. He does have to come, and then he again reiterated, he doesn't care, he doesn't want to be involved, he's not going to testify. So I'm just indicating that I did try to clarify that point for Mr. Williams when we spoke.
Is that right, Mr. Williams? She's on?
Yes.
I don't believe.
Don't words in my words. My word. Don't words in my words.
Who were your words?
Words was. I asked her if I got something. She said no. I told her my lawyer's name. The same thing I did with the detective.
So I am going to err on the side of caution, and I am going to hold Mr. Williams until he testifies at the preliminary examination. Sorry. Okay, thank you.
It's nothing I can do.
I can't, just can't. It's okay. It's all right. I know. Judge, we're asking you to reconsider that. Again, Mr. Weaves has indicated he will be here on November 30th. He will be here represented by counsel. And so we're asking for you to release him from the detainer, Judge.
No, I'm not. Thank you.
Yeah, okay. I know that, like, there's nothing I can do. Like, I'm telling you, I'm really.
I don't believe you.
Sorry.
Right.
Judge, would a tether satisfy you?
No.
Come on. Can I ask you one question, sir?
You're all set. Now about your turn.
Can I have a copy of the detainer, please, Judge?
I thought I gave it to you. I thought I gave it to you.
I give it back to you, Judge.
I gave it back to you.
Oh, yes.
What's up?
Here, represented by the same.
Did they take number? He has a number case.
They took him downstairs. I don't think they took him out of the building. I think they already know that.
Yeah. Just waiting on the attorney to get here. He's the same attorney on both of these cases.
They sure
But they're both here.
don't think
And I
they're
had,
probably not supposed to cross paths.
they're not. Did you call him? Okay, that's fine. It's gonna take a minute, Your Honor. We don't want to cross paths, so.
Okay.
Yes, I'm gonna go down and do it right.
Oh.
After here.
Calling case 2359886, people of the state of Michigan versus Brandon Jordan Crane. Still is charged in count 1 homicide, murder, first degree premeditated. Count 2 felony firearm, count 3 carrying concealed weapon. Appearances for the record.
Good morning, Your Honor. Anna Biggerstaff on behalf of people, P82215.
Good morning, Judge Patrick Nineheist, P76343. On behalf of Mr. Crane, is present. Your name, sir?
Crane. There's date time set for preliminary examination. We had some sidebar discussions and that I understand there's some outstanding discovery issues. Is that right?
That's correct.
That's correct, Judge.
Okay. And given the outstanding discovery issues and the defense attorney needs to be prepared to defend his client, the court finds due cause for an adjournment. I believe you have an agreed upon date of, what is it?
November 30th.
November 30th at 10 o'clock?
That's correct, Judge. Thank you very much.
November 30th at 10 o'clock. You wanted to address bond?
Yes, Judge, we asked for a DSU report, a pretrial service report.
We have one.
And I wanted to explain a little bit about Mr. Crane. He takes care of his 9 nieces and nephews, plus he has 3 kids, is that correct, Mr. Crane? And he has this case is from 2020, July 5th, 2020. He's still in the city of Detroit, still has strong family support. We're asking for a GPS tether with house arrest so he can take care of his nieces and nephews and his children. He currently also has, I got contacted by Joey Dominic, who works for the Youth Build, he's a Youth Build coach, and this program allows participants to get a stipend and start working and learning a trade as soon as possible. So he would be making between $400 to $800 a week. And he'd be learning a trade, so he'd have a trade to do after he completes that course, and be certified as an electrician or a plumber or whatever he decides to go into. The program started last week, but they kept it open for him until Mr. Dominic, D-O-M-I-N-I-C-K, said that it was going to be open for 14 days. Mr. Crane successfully completed the Homes Youthful Training Act from, I would say, the same incident, basically. He was arrested on July 5th with a firearm. And that firearm, he pled guilty to having a concealed weapon on him, successfully completed probation from Judge Wanda Evans of the Third Circuit Court. He's not a flight risk. And
Are you sure about that?
I am sure about that. Judge has been here the whole time since he got arrested on July 5th.
Of course he has, he's in custody.
July 5th, 2020, Judge, he successfully completed
He has an
probation.
extensive failure to appear. Did you know that?
No, I haven't had a chance to look at that report.
He has a very extensive failure to appear. He has an attendance charge. So they recommend no action. He's charged with first degree murder, premeditated. He has an extensive failure to appear history. For that reason, the protection of the community, and so that does not pose a flight risk. The court is going to remand.
Thank you, Judge.
Search that as well.
Judge, can I request that transfer from the last case with Mr. Weems? Okay, thank you.
Mr. Burgess here?
Not yet, yeah.
Weems, W-E-E-M-S.
Oh.
I think he is going to need a separate case.
Okay.
She gotta take the number of the case.
You already told me.
Right now, Mr. Burgess. Everybody has enough, Mr. Burks.
Sorry, Judge, I don't have Mr. Burgess. I have an email. Like that.
Anything else?
Track on that, he's not sitting all the way, someone else from all the way. That's it.
I'll be right back. Please.
Oh, wow.
It's the first sheriff.
But you can't do that.
So he
might use that.
Do you have witnesses on our next case? Hey, Mr. Johnson, how's it going? Good, how are you? All right. No. Is Herbert Robertson here? Do you have anybody here on Williams?
No, Your Honor.
Mr. Robinson's attorney there.
Okay, that's okay. Mr. Robertson, I'm gonna give you an opportunity. You can either wait on your attorney for a dismissal because the prosecution doesn't have witnesses in the case, or you can choose to represent yourself and ask for a dismissal. Now, wait, you're gonna represent yourself and ask for a dismissal. Let's do that, so we can get you out of here, okay? Herbert Robertson, calling case 2359530, people of the state of Michigan versus Herbert Henry Robertson. Defendant is charged with count 1 assault, intentional great bodily harm, less than murder by strangulation. Count 2 domestic violence. Appearances for the record.
Good morning, Your Honor. May I please the support Gabrielle Court requesting permission of practice under Court Rule 8.210 under the supervision of APA Shelley Grant.
Tell me your name, sir. Robertson. There's a date, time set for preliminary examination. Are you ready to pursue?
Your Honor, the complaining witness is not present and the people are unable to proceed without her testimony.
Mr. Robertson.
Your Honor.
Go ahead and answer.
Oh, ask for dismissal.
So order the court will dismiss this matter without prejudice. Thank you, sir.
Yes, ma'am.
We can do the same thing with defendant Brian Williams if he's here.
Williams, you have some much needed exercise today.
Williams. Brian Williams. Good morning, Mr. Williams. So we're waiting around on your attorney, but we have an option for you. You can choose to represent yourself and ask for a dismissal, or you can wait on your attorney. Which one to do? Oh, that's fine. That's fine. What's fine? All right, okay. Brian Williams, calling case 2359021. People of the state of Michigan versus Brian Ramon Don Diego Williams. Defendants charged with count 1 assault with a dangerous weapon, count 2 felony firearm, count 3 domestic violence. Appearances for the record.
Good morning, Your Honor. Gabrielle Court requesting permission of practice under Court Rule 8.210 under the supervision of APA Shelley Grant.
Commissioner Grant, tell me your name, sir.
Brian Williams.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the complaining witness in this case is not present and the people are unable to proceed without her testimony.
Sir, you have a motion for me? Sir, you have a motion for me? Motion to dismiss? Yeah. Hear you say it. That's why I have a motion to dismiss. So order the court will dismiss this matter without prejudice.
Thank you.
All right, thank you. And we are right on time for Mr. Johnson.
Sir.
Ryan Pearson. Calling case 2359520, people of the state of Michigan versus Rodney Frank Pearson III. Defendant is charged in count 1 assault with intent to do great bodily harm, less than murder by strangulation. Count 2 assault with intent to do great bodily harm, less than murder or by strangulation. Count 3 assault and resisting obstructing police officer. Count 4 domestic violence. Appearances for the record.
Good morning, Your Honor. May I please this court, Gabrielle Chloe, requesting permission of practice under Court Rule 8.210 under the supervision of APA code.
Commissioner Grant.
May it please, good morning, Your Honor. May it please Honorable Court, Bassett Johnson, 72130, Mr. Pearson states.
There's the date and time set for preliminary examination. Tell me your name correctly, sir. Rodney Frank Pearson III. All right. Are the people ready to proceed?
Your Honor, the people intend to call one of the arresting officers where we just went to check and see if they arrived yet. The officer in charge is in the hallway. Your Honor, per the officer in charge, the arresting officer is not here yet, but he's on the way. If the people could have him.
I was gonna say, the exam's at 9:45, we're here, that's dismiss the case.
I'll give them time to get there. That's just a little bit thing.
Yes, Your Honor.
I love to see.
Next one, 12 blocks. So you can waive resistance.
Mr. Burke said, on my way to be there by noon.
Who said that?
Mr. Burke.
There's no telling me already did.
Yeah, well. She said.
Witnesses on Procedural.
I don't care near that. I can't do I'll see you.
Thank you. Let me give them 3 more minutes. Give 3 minutes. Thank you, officer. All right, time's up. Calling case 2359520, people of state of Michigan versus Rodney Frank Pearson III. Defendant is charged in count 1 assault with intention to rape bodily harm, less than murder by strangulation. Count 2 assault with intention to rape bodily harm, less than murder by strangulation. Count 3 assault and resisting obstructing police officer. Count 4 domestic violence. Appearances for the record.
Good morning, Your Honor. May I please this court, Gabrielle Coy, requesting permission of practice under Court Rule 8.120 under the supervision of APA Kelly Grant.
Mr. Grant.
Thank you.
May I please on the court, Bassel Johnson, second, 72130, we have Mr. Pearson, 72.
Tell me your name, sir. Time present. Is the date and time set for the preliminary examination? Are you ready to proceed?
Yes, Your Honor. The people are ready.
How many witnesses for the hearing?
Just one.
Are you witness?
The people call Officer Niccolo Romano.
Sir, please step forward, give your name and spelling of your name to the young lady seated over here. Court report. Please raise your right hand to me. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat with the sponsor next to me. Keep your voice at a nice smile, speak to the microphone. Maybe begin when you're ready.
Good morning. Please state your first and last name for the record.
My name is Niccolo Romano.
Mr. Romano, what is your occupation? How long have you been working as a prison?
4 years.
4 years. What do you do as your roles and responsibilities as a prison?
As of now, I'm assigned 12 officers secretary.
And how long have you been with the secretary?
A year.
If I have one moment, Your Honor. Mr. Romano, were you working on October 20th of 2023?
Yes, sir.
And at that time, did you receive a dispatch call? When you received that dispatch call, were you in full uniform? What was the nature of the call? So the call took you to an address at 4216841 Tracy Street.
Yes.
What's the address again?
16841 Tracy Street. Was it in the city of Detroit?
Yes, ma'am.
And in the county of Wayne?
Yes, ma'am.
And at the time when you arrived, were you alone or with someone else?
I was with my partner.
Can you state your partner's name?
I know it was Officer Villanueva.
You were with Officer Villanueva. And when you arrived at the location, what happened?
My partner knocked on the door, got the young lady who was inside. I went to get a report number. I returned back. My partner was talking to Emmanuel, asked him to put his hand behind his back. He refused. I asked him to put his hand behind his back. He refused. My partner was larger taser. And he followed around. I pressed on something. He was transported into assisted violence.
Okay, I want to go back a little bit. You said that your partner was talking to someone who entered the door at Tracy Street.
Yes, ma'am.
And were you able to lay eyes on the person who entered the door?
Yes, ma'am.
And when you laid eyes on her, did you notice any injuries?
Objection relevant.
Why is that not relevant?
This is the police officer assault persistent obstruction.
There's also charges of assault, unless the murder of strangulation.
No more questions, Your Honor.
Now, Officer Romano, you're aware, Mr. No further question.
Sir, you indicated you were in full uniform, were you also in the marked squad car?
Yes, sir.
Can you describe the squad car?
I'm currently in a white Charger. Here, Detroit Library, as well as.
And when you approach the defendant, did you or your partner identify yourselves as police officers?
I do not know my partner at the time, but we were both fully.
All right. You were responding to a call, and you were encountered by a woman who said your partner was speaking. Yes. Let me ask this, people who seek to use the courtroom regarding domestic violence?
Yes, Your Honor.
All right, so did you take a report from this one?
Judge, can we approach?
Sure.
Sorry about that, Judge. We are ready to go back on record.
Okay, back on the record on People versus Pearson.
I believe you were asking some questions of the witness, sir?
Judge, we can approach, we had we had a sidebar in the hallway as far as clarification purposes. Can we approach him? Okay.
So my understanding, officer, is that you did not take the report from the woman that was in comment, is that right? This is your partner. Any conversation? Any questions based on my questions?
No, Your Honor, thank you.
No, just saying.
Thank you, sir. You may say.
No, Your Honor.
No, Your Honor, thank you.
The people move to bind over instruction and withdraw count 1 for the assault with intent to do great bodily harm. And we reserve any arguments as to count 2 and count 3.
Both counts are assault in terms of great bodily harm. That's the middle of my.
Oh, my apologies for the gap, Your Honor. We will withdraw counts 1 and 2 and move to bind over on count 3.
Just briefly, Your Honor, I would just say that based on the testimony, the officer didn't hear the conversation. He didn't with the young lady as well as my client.
Somebody bind over on that, just the assault on the
That's what I'm getting at. So with that charge, that's what we were talking about, sorry, the hallway as well. So regarding the officer not knowing what the conversations were, not knowing if Mr. Pearson actually called the police as far as his injuries go, all that wasn't discussed. So the jury instruction for 13.1 states that the officer has to give a lawful command. All that wasn't discussed in terms of his testimony today in terms of what actually happened. Like for instance, if they arrested the correct person or not. So with that being said, Your Honor, that's why I would ask that count 3 be dismissed.
Your Honor, as an argument about a lawful command, the witness testified that he and his partner both arrived in full uniform with a marked scout car. It's my understanding that the defendant is actually the person who called police, so he recognized him and he knew why they were there. The officer also testified that his partner told the defendant to put his arms behind his back. He refused. At that point, the witness told him to put his arms behind his back. He refused. At that point, the witness is the one who discharged his taser, and was able to put the defendant under arrest. Based on that, I believe the people have met their burden for probable cause, and it should be.
Judge, in response, Officer Romano wasn't the one who deployed his taser. Also, there was no evidence that he recognized Mr. Pearson because Mr. Pearson wasn't home when Officer Romano went to the location. But either made it. Exactly. There was no testimony on record in terms of that. So like I said, Your Honor, I asked him.
So I have a situation where witnesses partner talks to someone after, based on that conversation, he attempts to put the defendant in custody, tells the defendant to put his hands behind his back. The defendant refuses the witness to testify here today, then reiterates that and tells him to put his hands behind his back. He refuses again. Some kind of struggle, if you will, ensues thereafter, where one of the officers, I don't remember if it was this officer or the officer's partner, deploys their taser, get the defendant under control. So your position is that the officer to testify here today did he not give a lawful order?
That's correct. There was no facts and evidence to suggest that he gave a lawful order based on his partner's, I'll say, conversation with the individual at the home.
But the officer's partner, for whatever reason, was placing or trying to place the defendant in custody. Told him to put his hands behind his back. Was trying to put handcuffs on. But the officer that testified here today, there was no questions as to if you know why the defendant was being placed under arrest. He just followed up with saying, order to put his hands behind his back and put him in handcuffs. So who's to say that's not an lawful order?
Well, there was no, correct, precisely, as far as Warner's rendition. But there's no facts on this record today to state that it was a lawful order.
Your Honor, I would argue that any command coming from police while they are operating in their normal police duties is a lawful command. Police came to this address to perform a domestic violence call. When they arrived at that time, they were trying to investigate. They asked the defendant to comply by putting his hands behind his back. He refused.
It's not exactly true. As Your Honor knows, any command given by an officer doesn't mean it's lawful, just because an officer says something.
I would argue if they're operating under their duties, that would be a lawful command.
Doesn't necessarily have to be a lawful command, mean that you can resist an unlawful arrest. So I don't know if, based on the testimony we heard here today, I don't know if the command was lawful or not. So for those reasons, the court will dismiss this matter for insufficient evidence. Thank you.
Thank you, Judge.
That leads to domestic violence count 4, for giving the complaining witness failed to appear. We will be just spinning our wheels by sending this to Judge Garrett.
Yeah, Judge, based off of your ruling on count 3, the people will move to dismiss count 3.
All right, the court will dismiss the case in its entirety.
Thank you, Judge.
I need a dismissal order. I know you put out this for a different reason.
Oh, yes, sir.
Yeah, I'll second the public waiting on this. We're fine. Come back. Miss Tucker here?
She is.
Have her step in. Okay.
What's your name?
Oh, this is.
Thanks. Give me 1 second.
Oh, here's one.
You got one?
Here's one.
One over there?
This is the last one.
Okay. I got you.
Thank you, sir. So you ready to cook?
Yes, Your Honor.
great pictures.
Calling case 2359565, people of the state of Michigan versus Demetrius Lavelle Cook. Defendant is charged in count one assault with intent to great bodily harm, less than murder or by strangulation. Count two domestic violence. Defendant has a habitual criminal record.
Your Honor, showing the people, P number 60249.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Mr. Cook, who's present to my left. Thank you.
Good morning, Your Honor. Demetrius Cook.
Today's a date and time set for preliminary examination. Are we ready to proceed?
I'm not sure if I can just go check and see if something. Yes, Your Honor.
Yeah, see, so.
I just had the people who call Shiva.
Calling case 2359565, people of the state of Michigan versus Demetrius Lavelle Cook. Defendant is charged with count one assault with intent to great bodily harm, less than murder or by strangulation. Count two domestic violence. Defendant has a habitual criminal record. Appearances for the record.
Good morning, Your Honor. May I please this court? Gabrielle Pruitt, requesting permission of practice under Court Rule 8.210 under the supervision of APA Kelly Drain.
Commissioner Drain.
Thank you.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Demetrius Cook, who's standing to my left.
Morning, Your Honor. Demetrius Cook.
Today's a date time set for preliminary examination. It looks like people are ready to proceed.
Yes, Your Honor.
Now, give your name and spelling of your name for the young lady. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in this box right next to me. Keep your voice so nice and loud and speak to that microphone that's to the left. You may begin when you're ready.
I have to ask a question. First starter, can you state your name for the record?
Shayla Edmondson.
Ms. Essington, how do you know Demetrius Cook?
We lived together in a relationship
How long was that relationship?
for about 6 to 7 months.
And during that relationship, how often did you see him in person?
Almost every day.
Would you recognize him if you see him today?
Yes.
Do you see him in the courtroom?
Yes.
Can you please point to him and tell the court identification? Let the record reflect identification of the defendant.
So noted.
Ms. Essington, where were you on October 23rd, 2023?
At home in my bed.
Where's your home?
14564 long acre.
And that's in the county of Wayne?
Yes.
Who was at your home with you?
Demetrius Cook and my kids.
Did something happen between you and Mr. Cook?
Yes.
What happened?
I got assaulted.
When you say you were assaulted, what did Mr. Cook do to you?
Well, I had a puppy at home and he was basically woken up by the dog barking, and she's a puppy. She was like 7 weeks old at the time.
And I guess he got irritated by it and kept telling him to shut the fuck up, trying to get some sleep. And that's when I had told him like she's a puppy. And he was like, I don't give a fuck. And then that's when he had came to the bed and started choking me with both his hands.
While he was choking you, how was your breathing?
It wasn't good. When he kept choking me, I was trying to get his hands removed from around my neck, but somehow I lost consciousness.
Did you wake up?
Yeah.
What happened when you woke up?
My daughter and them was trying to come up in my room. And they was like, Mama, are you okay? And I told them to go back downstairs. And I said, yeah, I'm okay.
Were you assaulted again after your kids went downstairs?
Yeah.
What happened?
I got hit on the left side of my face and my eye.
What were you hit with?
His hands.
When he was hitting you, were his hands open or closed?
Yeah, the first time it was closed.
Approximately how many times did he hit you?
He hit me 3 times.
Was that the end of the incident?
No.
What happened then?
I finally got a went over there by my stairs.
And when you got up and went by the stairs, what happened next?
I had told him to calm down because my kids don't need to hear it. And he said he's out of this shit, he don't give a fuck. And that's when he pushed me into the wall. And I have a hole in my wall for that.
Do you have pictures of the hole in your wall?
Yes, I do.
What happened after you were pushed?
He told me to get the fuck out of his face. And he had pushed me again. So that's when my oldest daughter came upstairs and told him that he gotta go. And that's when they was trying to find my cell phone. And he had hit my cell phone, so I could call the police. And that's when he told me, like, I don't give a fuck, I'm about to call the police myself. And when he called the police, he told them that he was trying to get out the house, trying to play victim.
No more questions.
Person back.
Afternoon, Ms. Hamilton. So you're saying, that Mr. Cook, without any provocation, just came over to the bed and started strangling?
Yes.
Was there any type of argument beforehand?
No.
What time of the night or the morning was this?
Don't really remember.
Was it in the middle of the night or was it during the day?
It was like in the middle of the night. Everyone was asleep.
That night, did the two of you have sex?
No.
At any time, did you hit Mr. Cook?
I pushed him off of me and I hit him back.
Do you remember hitting Mr. Cook with a bat?
No, my daughter did.
Do you remember chasing Mr. Cook down the street?
I didn't chase him down the street.
Did you have any visible injuries?
I had strangulation from my intimate marks. I still have them on my body from getting choked and getting hit in the face.
What type of marks did you have?
Scratches and bruises.
No further questions, Your Honor.
Can you redirect?
Legally, Your Honor. Sorry. Ms. Essington, were you and the defendant in a discussion before the assault?
No.
Did you previously testify about the dog?
Yes.
Was there a disagreement about the dog?
Just based on the dog making noise.
Did that disagreement have anything to do with the assault?
Yes.
In what way?
getting upset at me because I said something pertaining to the dog that she's a.
So why did he assault you?
Because my dog was making noise.
Previously, you testified that you were at home when this happened.
Yes.
Do you own that home?
No.
Nothing else.
Thank you, ma'am. You may step down. Any other witnesses for the people?
No, Judge.
Any witnesses for the defendant?
No, Your Honor.
People?
The people moved to bind over as charged on third here.
So,
There's a question for the sergeant.
I agree. Here's a question of fact. For opportunity to testify, the silent ethics is satisfied people met their burden of probable cause as it relates to the charges contained in the complaint. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this was been committed. Defendant will be bound over to Wayne County Third Circuit Court Criminal Division for the proceedings. His arraignment on the information date and time will be November 22nd, 2023 at 9:00 a.m. Bond will be continued.
Your Honor, can we address his tether? He's not trying to have the tether come off. He lost his job because he's on house arrest, Your Honor. If he could just have tether off hours so that he can try to obtain a new job.
Your Honor, the people will argue that there shouldn't be any changes to the tether restriction. The defendant is also charged as a hat for, he's dangerous. We have no reason to believe that he wouldn't contact the complaining victim.
Does he try to contact?
No, Your Honor, he has blocked her, and yes, he is a half word, but his charges, all of this stuff is from 2007. He spent 10 years in prison, Your Honor. Got out in 2016, has had no contact with the law until this unfortunate incident, Your Honor. And we're not asking for the tether to be removed, Your Honor. They will still be able to find him where he's at. He is not allowed back to her house, which tether can track it, Your Honor. He is just trying to simply find another job because he has lost this job. When he was in jail for those days, they were considered a no call, no show. And by the time he got out of jail, they basically fired him. It did not matter that he was in jail. He had a reason for it.
So you don't have a job?
No, sir.
It's gonna be kind of hard for you to get a job anyway, isn't it? With your criminal record, and then with these cases coming against you.
LM manufacturing, doing car seats for GM, for Ford. I was working, doing another job, taking care of my son, which he's 3, which is his mother has sickle cells. So she ain't gonna be able to do nothing for him. I was doing another job, which is self-employed, taking care of my grandmother, which is in the same household, and we was doing everything else. I can't do nothing without me being on this telemonitor and me being tracked every day. I gotta be able to be off to be able to manage all these type of things.
Your attorney's asking me to adjust the tether.
And I did explain that the tether would not come off for the duration of this, this case. And I did explain to him that the most I could get was him tether hours so that he can find another job, because it didn't work for L making car seats for General Motors and Ford, so he can look for another job. He's lost that job. It's gone. So.
Your Honor, I would still argue to keep the tether reinstated. As you mentioned, the defendant doesn't have a job right now. He just said himself that he's not able to find a job as long as he has a tether.
The tether's not gonna keep you getting a job, is it, sir?
No, Your Honor, I've had other clients who have been on tethers and have been able to get another job. He just has to look. And since he has to do most of the care for his 3-year-old, because the mom has sickle cell, he needs adjustment. And being on house arrest is not helping him or helping his son.
You're not on the road? We need to complete the road.
Clear for roll 2017, 2018.
All right, I'll give him 9 times.
Thank you.
Good job, sir.
Thank you.
Thank you, Judge.
Check out there, Mr. Parker.
Good. What about yourself, sir?
Doing good, thank you. Are you ready on the board?
I am.
First, Mr. Warren. Calling case 2359613 for the state of Michigan versus Zach Harris.
Yes, sir.
Harris Kendall Warren. In this charge with count 1 home invasion, first degree, count 2 assault with a dangerous weapon, count 3 and 4 felony firearm, count 5 domestic violence, count 6 assault or assault with battery. Appearances for record.
Good morning, Your Honor. For the people, even 6-0-2-4 now.
Good morning, good afternoon. James Parker on behalf of Mr. Harris Warren. P 53832.
Tell me your name for the record, sir.
Harris Warren.
Yes, date, time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor. The complaining witness is Megan there.
Yes. Are you with us?
One moment. She entered me wrong. She's right here. She can spell it.
Now, please step forward, give your name and spelling to the young lady seated there. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. I need you to spit the gum out and have a seat and witness stand right next to me. Speak nice and loud into the microphone with each of your left, okay? You may begin when you're ready.
Thank you. Please take your first and last name for the record. Ms. Brown, how do you know Warren Clark? Make sure you're speaking into the mic, okay?
My kid that
How old is your oldest child?
During the time that you've known Mr. Carr, how often did you see him in person? I'm sorry, one more time.
All the time.
Would you recognize him if you see him today?
Yeah.
Do you see him in the courtroom?
Yeah.
Please point to him and tell the court item of clothing he's wearing. Let the record reflect the identification of the defendant.
So no.
Ms. Strong, where were you on October 17th of 2020? And what city is your home in? What county? While you were at home, what happened?
You have to speak into the microphone, I can't hear you.
I was arguing with Paris through text message.
And while you were arguing with Mr. Warren through text message, what happened after the text message? Were you expecting him to come to your house?
Ma'am, I need you to speak to the microphone.
No. Ms. Strong, you can pick that microphone up from the bottom part and put it in your lap. And just please do your best to speak directly into it. Okay, so you just testified that Mr. Warren came to your home.
Yes.
While you were texting, did he tell you he was coming to your home?
Yes.
What was your response to that?
Don't come over here.
And he still came to your home?
Yeah.
How did you know he was at your home? Did you open the door?
Yeah.
You opened the door?
I opened the door after he said he was gonna kick it in.
Okay, I wanna go back to when he first got to your house. When he first arrived, how did you know he was there?
My mom, he knocked on the door, my mom said, who is it? They was him, I said, don't let him in.
You told your mom not to let him in?
Yes.
So when your mom answers,
You can.
what's your other question? Why did Mr. Warren say he was at your home?
He said he came to get the kid.
At some point, does Mr. Warren end up in your home?
Yes.
How does he end up in your home?
When I opened the door, he pushed past me.
Why did you open the door?
Because he was saying he was gonna kick it in. So I opened it. He said he was coming to get the kid. I was going to get the kid already.
So prior to you opening the door, approximately how long had Mr. Warren been at your home?
He had just got there.
So after he pushes in, what happens?
Say, ready to get the kids. I'm going to get the kids ready. Me and my mom at the door. Going back and forth, get the kids ready. He pulled his gun out. He waited at the door, telling me he'd shoot me. He'd kill me. I got the kids ready so he could go. And he was on his way out the door. And he turned around and spit in my face.
I want to go back, Mr. Sorry for interrupting. You said that at some point while he was in the house, he pulled a gun out. Can you describe that for the court?
It was a black hand with a piece on the bottom.
And while he was swinging that gun, did he point the gun at anyone?
No.
So what was he doing with the gun?
Waving it around.
And while he was waving the gun, you testified that he was saying something?
Yeah.
What was he saying?
He killed. You know, mine, 35 years for killing me.
How did you feel while he was waving the gun around and saying these things?
I felt a lot of different things.
I didn't hear you.
I felt a lot of different things.
Like what?
I'm angry.
Ms. Strong, at some point, did you call the police?
Yes.
When did you call the police?
When he left.
As soon as he left?
Yes.
No more questions for this witness, sure.
Man.
Yes.
Mr. Jones, so you and Mr. Warren go back, what, since you were 16 years old?
Yeah.
And you have 2 children in common?
Yeah.
So you've had this relationship for around at least over 6, 7 years? Fair to say?
Okay.
So when you first started texting Mr. Warren on that day, he mentioned he wanted to get kids, that fair to say?
No,
Never mentioned the kids?
he did not say nothing about coming to get the kids.
Nothing whatsoever, so he just wants to come over and see you?
He did not tell me nothing about coming to get kids, nothing, we was arguing in the message. Nothing, he never said, I'm coming to get the kids ready or nothing. You said you was coming over here. I said, don't come over here. Then you at my door now, if you're coming to get the kids. Okay, so I'll get the kids ready so you can go. But he's never coming to get the kids because as soon as the police left, his grandma dropped my kids back off.
Well, you know, the grandmother lives real close to you, that fair to say?
Yeah.
Right next door?
Yeah.
And previous times, you and grandmother have been used as what? Babysitter for the kids?
Yeah.
Many years?
No.
Well, how long?
She just started really watching get them. Like,
Just recently?
she would watch them from time to time before, but it wasn't how it just was.
Well, I'm just trying to find out, you know, but it's fair to say that she always watched the kids.
She don't always watch them.
Well, she has watched them.
Yeah.
And prior to this event that brings us all together, I can't remember, it was 10/17, what day of the week was it? Remember?
It was Sunday, October 15th.
It was Sunday. Did Mr. Warren and the grandmother have the kids 2 days prior?
Yeah.
Objection, Your Honor. I'm not sure why the parenting agreement is relevant to the charges.
Well, I feel that when the witness stated that, you know, he wasn't there to get the kids, and let me tell you the reason why. She mentioned that because the grandmother was there and the grandmother brought the kids back to the house. I just wanted to explore the relationship so the court knows, realizes between the grandmother proximity to this particular.
Why do I need to know that as it relates to these charges?
Well, the charges are somewhat based on the fact of him being there, if he was allowed to be there, what was the understanding of him being there? And I just feel that this just gives the court a little bit more of a background to that. But I'm not gonna ask him a question. So while you were there, you said your mother was there, right?
Yes.
And your mother had interaction too, right? And so did you ever see, you say that you see Mr. Warren waving a gun around, is that correct?
Yes.
Did you ever see Mr. Warren put the gun in the drawer?
I didn't see anything.
So did you ever see him, you said he went, what, upstairs to get the children ready? And then, so when you came back down, did you see Mr. Warren with the gun?
Did I see him with a gun?
Yeah, when you came back downstairs.
Yes.
All right. So did he ever leave that house or either leave the house and then come back?
He left,
He
and he
left.
turned around and kicked my door in.
Did he come back in?
No,
Did he leave with a weapon?
no,
Did you ever see him with the weapon? So you never saw him let me ask you one more time, you never saw him just put that weapon in the drawer?
I never saw him put the weapon in.
So when he and you were texting, did you provide any of these texts to the prosecutor?
She said she was gonna, the officer said she was gonna get him, but she never got him.
Okay. I have no further questions of this witness.
Can you redirect?
Yeah, briefly, Jim.
Mr.
I want to go back a little bit. You testified previously that Mr. Warren pushed his way into the home. You also testified previously that At some point, he pulled out a gun. You testified that while he had the gun out, he made threats. And he just was waving it around. What happened after he stopped waving the gun? What did he do with the gun? He put it in his pocket? What pocket? His coat pocket, his pants pocket? Okay, was he wearing a coat like he's wearing now or a hoodie? No questions.
All right, thank you, ma'am. You may step. Any witnesses for the defendant?
I have none at this time.
The people moved to bind over charge under the video.
I feel that there's enough for a bind over, especially on the charge of home invasion. Feel that there was a discussion. I've been over their house many times before.
That may be the case, but didn't she testify that he entered the house without her permission?
She at this point in time may have said that she did not want him there, but when he got there, he came in and stuff, and then afterwards.
I thought I heard that he pushed past.
But she opened the door, he came in, I mean, Your Honor, this is a situation where they've been in a relationship. He's been over that house many times before, he's come through that door and stuff.
And those other times, he may have very well had permission, but on this occasion, she said she didn't give him permission.
Well, I don't feel there should be a home invasion. If the court is inclined at entering without permission, it's a more appropriate charge for this type of situation. But I feel that, again, they did have a discussion about him coming over. And whether she wants to say now that she feels that I didn't necessarily want him in there, she's certainly not exact or, to the point that you can't come over here, not allowed here, or anything like that. So I feel that the home.
Even though that's what she testified to here today?
Well, I don't think she really testified to that as directly as on point that you possibly can. I feel this court could always look at the credibility of this and make a decision. So I feel that, you could look and see the way she testified, what she said, and feel that, she was wavering on this.
Your Honor, the complaining witness testified that she had a relationship with the defendant for 6 years. They grew up together. I don't think she presented any credibility issues aside from being a little quiet. As to the charge of breaking and entering, she did testify that she told the defendant not to come to her home, that her mother, who also lived there, told the defendant that he was not able to come into the home, and that she only opened the door because he was threatening to kick it. At that point, when she opened the door and let him know, hey, I'm gonna get the kids, I'm getting the kids ready for you, that's when he pushed in, and much more happened once he got into the house. Based on that, Judge, I don't think the people had met their burden on all the elements of bringing in or
Yeah, the much more that you're referring to is him putting the gun out, waving the gun around, putting a reasonable person in fear after he was battered with that dangerous weapon. She testified that she did not give permission for the defendant to enter the home, although she did open the door. She didn't give him permission to come in. He did that, and allegedly, when he did so, he pulled out a gun and started waving the gun around. He got his kids. It's not the way we do things. So, by the letter of the law, people have met their burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this committed. And it can be found local to Wayne County Third Circuit Court. Proceedings is arraigned on the information date and time being November 22nd, 2023 at 9 o'clock a.m.
Thank you, Your Honor.
Yeah. Your Honor. Thank you. Have a good day. You guys all said, you come up.
Say it again.
You sure can. No. Have anybody here, Ms. Nance here on bill?
Yes.
Okay, let's have it. Right along.
Interview the person. Essential people, the town, and everything. Okay.
That sounds good. I'll take a look at it. I'll send it to you.
Nonsense to you. Yeah. Yes. Order.
Let's see. We just put it, what emails you send it to us. Okay, see. All right then. See if the other people.
Yes, how are you? I'm well, how are you?
Good. You ready, Mr. Brown, Mr. Bell?
We are, Judge. Yes.
Calling case 2358677, people of the state of Michigan versus Cosile Bell. And discharge to count one assault for any 12, count 2 aggravated domestic violence.
Good afternoon, Your Honor. Shelley Drake for the people, P number 60249.
And good afternoon, Judge. May I please support Jeanette Edens, P 68686, here on behalf of Mr. Bell. Mr. Bell, please state your name for the record.
There's a time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is not present, and I do not believe that the testimony today.
Judge, therefore, we usually dismiss without prejudice.
So ordered, the court will dismiss this matter without prejudice.
Thank you very much. Judge, there's also a tether on Mr. Bell's ankle. Could the court set the order?
The dismissal order will take care of that.
Thank you very much.
Thank you.
Well, have a great day.
You too. And then there's one.
Wait, you're taking, oh, it's not it.
You guys are amazing. You handled that huge docket like it was nothing.
Thanks,
Good job.
You didn't give us much choice, so that's fine.
Good job.
Oh. Judge, we were wondering for Thanksgiving, I heard you mentioned that you're going to be here for that week. Is that right?
Just on the 21st. I'm coming in for that day.
Oh, okay. Okay, but otherwise,
That's not your guys' day.
oh, okay,
That's a Tuesday.
okay, so we probably won't be scheduling any exams for like, okay.
I'm trying not to.
Oh, that's so nice of you.
Just.
Said try. You said try.
Thank you.
No, not.
So we got people.
Possible.
Has somebody else working here.
Okay. You just get about change. Okay, take your time. Huh?
Ms. Pruitt.
Yes.
Come up for a second. I was going to tell you just a couple of cosmetic things.
This one.
You have a witness up there, you ask the witness, how do you know the defendant?
You told me from the approach.
I mean, come to the photo. You do that, you are assuming the facts, not evidence. So you say, you know the person's name, that person's here. The other thing is, so something happened with Mr. Cook, you can complete that with, that brings you forward to it. How do you know Mr. Cook? Just change that to, you know, person by the name of whatever his name is, Cook. That way you're not assuming facts, not evidence.
You don't have any cosmetic comments for me? I know that's very good.
Both of you are very, very good. In fact, Ms. Pruitt, your popularity is really growing on YouTube. Yeah, they say that you're gonna be really good, that you're really tough. And all that good stuff.
Oh, yeah, I appreciate that.
She thinks fast on her feet, I like.
She does, yes.
And you did very well too. Obviously, this wasn't your first time making an appearance, so.
No.
I could tell it wasn't. Both of you handle yourselves very well. You both very good.
Thank you.
Hopefully you'll stick around and not jump ship like all the other prosecutors.
No, I want to be a judge one day, that is my ultimate goal.
Okay, good for you. All right.
Everyone have a good afternoon.
Thank you.
Bye, everyone.
So this is our last case with it.
Oh, yeah, all right. I'm there. Because of discovery, that was one of those forms I had to send in this morning to the prosecutor. So I think this office call.
So next case has 1:30.
Dismissal. Yeah. This is dismissal on bail, it's naturally dismissal. That's it. You ready to start at 1:30?
Yes, sir.
Okay.
So we can get it done.
To get it out the way.
It's running today. We had that many calls and that's the final.
Yeah, victims for showing up today. Yeah.
Still got it done.
Just not trial.
So let me ask you something. You're on 1:30?
The pondering. I thought it was at 1.
Is that 1:30?
Oh, is it at 1:30?
So you're good.
I'm good.
The defense attorney called here talking about the stuff.
Yeah, so what had happened, Judge, during the probable cause conference, I had emailed over, the kids talk order. I didn't get it back until this morning. I had emailed a few times, called your clerk, and left
So
some
the kids talk
messages.
video was everything he was missing?
No, so here's the thing, on evidence.com, I'm a new attorney here, so if I'm not doing it right, I'll find out. I've been in trial, I have to know to figure out. So the kids' talks are linked on evidence.com, all in the same case. So if I'm gonna share anything on there, it sends everything over. So I wasn't able to send over the kids' talk, and there's actually 2 kids' talks on this case. So I contacted
How
the.
long are those videos?
The one kid's talk, I think is probably about close to an hour. The other one's a little bit shorter. So, and there's also body cam video that he needs to watch. And there's also an interview that was done with the defendant back in June. That he needs to watch that interview. I was actually gonna admit that into evidence today.
So in other words, he's not going to be ready.
No, and I knew he wasn't gonna be ready for it. I've been in contact with him. I basically called him a couple days ago and said, you know, this is one investigation, but it really stems from 2 investigations. I told him what discovery is out there that he hasn't received yet. I explained to him why I couldn't give it to him. I couldn't figure out how to separate the evidence.com, so that he would get everything except for the kids' talk. I did give him all the paper discovery from both investigations, but I have been continuing forthcoming with him, so I figured this adjournment was going to be
When will you be able to get all of that?
tomorrow morning, Judge. And then I have to figure out the date. I apologize. Let me see. Judge, I'm in trial like almost every day this month. That was why I wanted it to go today. Because I was like, but I can't send them the kids talk if I don't have a kids talk order. I'm in trial on that day. I can tell you that I have the 22nd is one day I have open, and I could actually do the 17th, which is actually sooner. I could do that in the afternoon. I do have to do it in the morning. Other than that, Judge, I'm in trial. If he's available, yes. And I'm sorry I have such limited days, but I'm in trial almost every single day this month.
So I'm thinking 17th, about 12.
Yes, Judge, I have 2 hearings, but I should be number 12.
So we'll wait till he gets here and see what he has to say.
Thank you, Judge.
She is here, can I talk to her?
Yes. Well, Arnita, can you do dismissal? Miss Nancy's waiting on the dismissal. So she can, because her client got a tether. Yeah. It's up there on the, thing. It's like that 1:30. I know, I feel you. Miss Tucker is gonna, did she talk to you? Yeah, she's gonna email a order
You know what?
to reduce the violence.
Right. From now on, it's blank orders, they can just write them up while they're here.
We got blank orders?
Yeah,
I didn't.
because when I have to wait on them, and then,
Wait a minute, this is what this is right here.
it's blank or order, yeah, they can write stuff like that on those blank orders, so they can immediately give it to me, so I can complete my file.
Did she ask for one? I
Oh,
said,
did she?
yeah, I didn't know we had
Yeah.
it. Okay.
Yeah, because that other attorney, he left this morning that he was supposed to send in an order, I don't have that one yet.
Well,
It's like it-
well,
it
she
holds
knows
me
that that
up.
bond can't be reduced if she get the order in.
That's what they don't understand, so I still have to put it in as is.
Okay.
And then when they send me the order, then I'll go in and put the order in.
Right.
But they, client can't do anything until the actual order.
She might have emailed you already or emailed the court, because she said, it sounded like she was gonna go do it right away.
It's down, so we just get it.
Okay, thank you. Which kids you
Huh?
Yes. Let me show you how to check.
All the paperwork was good. Good job. Now what?
Last case, he's out, that was him, right? Okay.
That's gonna be adjournment.
I believe so.
Defended don't look that much over 13. Kids. It was probably consensual, but she was underage. Try to tell these kids you can't do that stuff. We used to get away with a lot when we were growing up, but now you can't do that. If we did what we did when we got, we'd be in prison.
Our parents are in prison for being.
I'm glad I don't have no little kids now.
I know my parents were being.
I know now we took, doing life. I swear they murdered me 2 times. And that's fair to ride. Want a punishment or you want a whipping or a punishment?
It helped you. So you turned out to be pretty good.
See, back then we wanted to go outside, so you like give me that whipping. But today kids don't even want to go outside. You like, go fight in, no problem. Yeah, on the phone.
On the phone, on the game. The
Yeah,
game on the phone.
it's a way to turn the internet off. Now nothing works. Lock the internet. Huh? You do?
That's the day.
Really?
Yeah. Tell me you need to come in tomorrow.
I'm not off the road, so I'm all.
Let's see.
Come in tomorrow.
Let's see. My courtroom changed every day. I gotta see where I'm at. Yes, me and Crawford.
Tomorrow?
Yeah. See Crawford. Right, Watson, you road.
Well, y'all working today.
It's good. It's raining today, ain't nothing I can do out there. Now, let me tell you.
Extras.
On the 14th, which is Tuesday. I'm in here on the 13th. No, on the 48th. What's
So
going on
the
the 13th?
13th, we got 14 exams.
Oh, domestic violence? Yeah.
Oh, yeah, 17 today. When was somebody 17?
So on the 14th,
We got 5 exams.
which is a Tuesday.
Yeah, homicide.
Yeah, Judge Archer got a case at 1:30. That's extra.
Oh, that must be a remand back case.
Yeah.
She's on traffic.
Yeah, or yeah, for some reason it's some, Yeah, they got kicked back to her.
Okay, she heard, and when it came back, it has to go back to her.
Mhm. It's on the 14th, so we need all officers, nobody call off, nobody be late. Boss.
Yeah, I'm on the fourth floor, 13th.
I'm talking about the 14th. Oh, I said, not on here.
So if every Tuesday.
We need you to come in. Need you to come in. Because we got that extra case. So we got 5 courtrooms.
I take my retirement seriously. I don't really hear
Yeah. Oh, good. Get your car up the shop straight. All right. Don't need us no more, right?
I was thinking in there, she have done me on sure. Yeah, can't move all day in a while.
I didn't show up.
I know that. I didn't know that. It was 2 rows. 'He was gonna be my excuse till I saw his 2 rows.
Yeah, I got to deal with my brother for lunch, and since he lives in Sterling Heights, we gotta wait till stuff. They still open there.
It's okay,
I don't get on the salad.
Four shots and 7.
I'll pass on that part. Now, somebody recently said he went to Ford's Garage, is that you? Man, that place is the bomb too. Y'all been to Ford's Garage in Dearborn? It's a restaurant. Yeah, it's nice. It's not real high, but great food.
Well, back to Southern Fire, this was.
Brisket sandwiches and everything. It's just nice salads. Oh,
I took it right there. What's it called? Ford's Garage.
Ford's Garage.
Trying to get new stuff all the time.
Right on Michigan. Yeah, right on Michigan.
AM to 10:30. Friday, Saturday.
I know.
Every month, 16 hours. That's a lot for weeks.
It's just that time where you gotta,
It's really nice. It's a really nice.
Okay, so on the inside, it's built like almost everything's like, when I say Ford's Garage, I'm talking about the automobile Ford. Everything is propped for automobiles, yeah. The menus and stuff, but the food is absolutely delicious, and they have brisket sandwiches, great salads, everything.
All right, you convinced me.
Yeah.
Let's see, it's fine. Here, we'll say reservations. Charlie.
Not all the time, no, but it's a nice size, it's big. They have a bar, and a lot of people eat in the bar area. Hey, Beth, how you doing? Okay. I had to wait maybe 15 minutes before 15 minutes. All right, let me see what's going on.
Did he say hello, we're done?
He's coming back
He
out.
said it's coming up from one. Let me just see if Mr.
Yeah, he's coming. Mr. Burgess got this, right? Voicemail.
He goes, Did he ever show up?
Yeah.
Mr. Burgess? Or maybe his
Two
client,
cases.
his client must have told him they got this.
They must have, but still, judge said they have to come down anyway.
Yeah, I think so. Is he watching, so?
Right. Oh.
Attorney Lanning's here, so as soon as the judge can get him, call me. Everybody's here.
Let's get it done.
Still come on in. Still come on in. Bang, bang. I'm hungry.
You really make it a cricket hurry.
I was irresponsible with it, and my bad. I want to eat what you got. No.
We have a week. I think you're.
I came back.
I'll make a note of that.
Please do.
James, I really eat. This is gonna happen. This is gonna happen. Flash.
Why do you have my? Yes, sir.
We'll get it paid back.
I'll be at home.
Just. Care about nobody, just. dismissed, sir.
Mr. Lamb.
Hey, good afternoon, Judge King. How you doing, sir?
All right, what's our status here?
So we're going to be requesting an adjournment.
That's what I heard.
Now, the prosecutor's on board, our prosecutor's on board with such as well.
That's what I heard. I heard you didn't get the kids talk tape.
That is correct, that is correct.
What you got on there, Judge King? What?
I need to get a closer look at that shirt. What is that there? Okay.
Should have seen the one yesterday.
What? Yeah, they ain't a part of the tie though. That ain't a part of the tie, right? That's the color of the shirt.
Right.
Yes.
Okay. So Mr. Blake wants to continue on the Woods case. Is he gonna keep the same exam date? Joshua Finding, Calling case 2359602, people of the state of Michigan versus Joshua Palmer. Defendant is charged in count 1, criminal sexual conduct, third degree person, 13 through 15. Count 2, assault with a dangerous weapon. Count 3, carrying a concealed weapon. Count 4, domestic violence. Appearances for the record.
Good afternoon, Your Honor. Tiffany Woods, E861894 people.
Good afternoon, Your Honor. Michael Lamb, P79816, appearing on behalf of Mr. Ponder, who's president to my left. Sir, will you please state your full name for the record.
Mr. Judge came with it, Joshua Ponder.
There's date, time, set for preliminary examination. Are we ready to proceed?
Your Honor,
Your Honor, so we are now prepared to proceed at this time. We are respectfully requesting that this matter be adjourned. I have yet to receive all of the discovery that I need to review with my client. I had advised my client of the 21-day rule, and he is prepared to waive his right to the examination within 21 days of the hearing in the event this matter is scheduled past that time frame.
All right, court finds good cause to adjourn the matter. Now here comes the tricky part, the date. Can we do November 17th?
November 17th, Friday. Would that be in the afternoon, Your Honor?
I can do the afternoon, does that work?
I would need the afternoon as well, Judge, that's what we're missing.
Okay, November 17th at 1:30.
Understood.
Or 12 o'clock, sorry.
12 o'clock?
Is that good?
That might be a little tight for me, Your Honor. I have some matters I gotta deal with at Third Circuit Court.
Anytime in that afternoon works for me, whatever works for.
Let's say 1:30.
Thank you, Your Honor.
November 17th at 1:30, bond will be considered.
Thank you.
Thank you.
So I know you don't want me walking around here looking like you, Judge King, but I just gotta know where you copying these shirts at.
If I tell you, I
already know. I knew I wasn't gonna get it up out of you. Even if I promise not to come to your courtroom dressed like you, I still ain't gonna get it.
I have to cut it.
Fair enough. Fair enough. Take care, sir.
Have a good one.
You do the same.
So that concludes the docket for today. Hope to see you tomorrow. On Friday, so I hope to see you Monday, same back station, same back time.
See you next week, Judge.
All right, have a good one.
Not tomorrow, have a great day.